Okay, good morning, everyone. Welcome to SCORE Bucks County's webinar on surviving to thriving, addressing HR issues in a post-pandemic world. Before we begin, I'd just like to give you a few housekeeping items. First of all, you will all get a copy of the slides as well as a recording of the presentation today, probably a few hours after the session ends. Please, if you have questions as we go along, and I'm sure you will, use the Q&A to put your questions. We'll address everything at the end of the session. And please refrain from advertising your business in the chat. Okay, just a few minutes about who we are, who's presenting this webinar to you today. First of all, my name's Linda Zangrilli, and I'm the chapter chair for SCORE Bucks County. If you do not know anything about SCORE, I'd just like to spend a couple of minutes explaining what we do, who we are. We're a national nonprofit organization. We have some 350 chapters all over the country and between 10 and 13,000 volunteers. Our mission is a very simple one. It is to help small business start, grow, and thrive. So we do that through webinars such as the one you're going to hear today, as well as free mentoring services. So if you're in a small business and you need help, maybe you're just getting started, but you're not sure what to do, or if you've got a business going and maybe you're kind of stuck in the mud, need a little push, please reach out to us. Our website is buckscounty.score.org. And I believe we put that in the chat so that you can see it. When you get into the website, just say, I need a mentor, and we will take it from there. We'll assign a mentor to you. And as I said, all of our mentoring is free, and you can have as few or as many sessions as you would like. In Bucks County here, we cover the entire county as well as Eastern Montgomery County. And we have some 70 people who come from all walks of life, all types of disciplines, skill sets. So whatever you need to get your business moving, we most likely have that in our chapter. And if we don't, we have those 13,000 people out there in the United States that we can also reach out to for help. So please don't hesitate if you need some help with your business to reach out to us. Well, today I'm going to turn this over now to our seminar chair. He's the gentleman who brings all this together for you. Every week he has a new topic. We have a presenter today who's familiar to SCORE. She's actually with one of our partners. She's the incoming president for NABA, the National Association of Women Business Owners. So I'm going to turn it over to Ed, who's going to talk a little bit more about Christina, and take it away, Ed.
Thank you very much, Linda, and thank you all for joining us today. We're very fortunate to have Christina Reger, who's the founder of the law offices of Christina Reger, LLC, and now also Lutel Law. Christina is the founder of our offices, and she's also a certified woman WBE person. She handles litigation and counseling matters related to labor and employment for corporate, entrepreneurial, and startup enterprises. She's been a counsel to many businesses, and she's very familiar with everything going on in this whole area of basically labor relations and human relations. I'm going to turn it over. She has an extensive background. It's all listed on the, I guess you'd say the registration form that we put out, and you can read all of the different groups that she's a member of. But it suffices to say she's extremely knowledgeable, and I think you're going to find this very, very interesting. Christina?
Thank you so much. Thank you, Ed and Linda and Charlie, for inviting me to speak again. It's so great to be here with SCORE. We've kind of weathered the pandemic storm together, I feel, over the past couple of years, and done a number of presentations throughout the pandemic on what business owners can expect, what they should be doing, what laws apply to them. And now the presentation focuses more on coming out on the other end and coming out successfully. And so what I tried to do for my presentation today was to really focus on what businesses need to do to get to that next oops, sorry, don't know how to work my slides, to get to that next plateau and really start thriving on the other end of this world, which doesn't look the same as it did 2 years ago. So I'm happy to be here. I love to answer questions. We have a huge agenda of a lot of different topics. So put your topics in the Q&A. I'm happy to answer them throughout the presentation, just so we're not referring back to something that was 6 topics ago. So I think it's easier, makes more sense, and I'll make sure that I watch my time, Ed and Linda and Charlie. So, but just a couple disclaimers. I'm not giving legal advice. This doesn't create an attorney-client privilege, and always I'll try to answer your questions as generally as possible, but do offer discounted consultations for SCORE members or people that have attended the SCORE presentations to assist with their business needs. So let's go from there. So here's our agenda. As I mentioned, it's pretty full. We're going to talk about returning to work. Still, I feel like we've been talking about returning to work for quite some time. We're going to talk a little bit about the virtual world. We're going to talk about the Great Resignation and how it relates to non-competes and non-solicitations. We're going to talk about attracting and retaining talent. We're going to talk about the status of arbitrations. We're going to talk about DOL issues, and then we're going to round it up with kind of next steps after hearing all of this, kind of what do I do now? Where do I go from here? So lots of things to discuss and ask away. So returning to the office, this is, I feel like this is more of a problem, at least what I'm seeing is getting people to return to the office seems to be the bigger problem. Businesses, business owners are ready for their people to come back. And I know many of you, whether you're a solopreneur or a small business that operates in the product or services industry where you might have people that had to be in the office, whether you're a massage studio or a salon or a store, like your people couldn't telecommute and operate at home. But for those of you that do have offices, returning to the office and getting people to actually return to the office has been a challenge. And also what I'm seeing is people are willing to either quit or leave their jobs or lose their jobs because they don't want to return to the office if it's a job that they can do at home. They're content at home, they feel they're productive at home, and so they want to continue to do that. And so I think that this is feeding into that Great Resignation that we'll talk about. But my first point for business owners that are kind of evaluating or reevaluating or looking at this return to the workforce is look at which jobs need to return and which jobs maybe can stay hybrid or be completely remote. And there's kind of challenges with that as well, moving beyond the COVID era. And we'll talk about that, but just doing like a deep dive evaluation of which of your people really don't need to return the office. Do you need all that space? Can you give some of it back? Can you co-lease it or sublease it to someone else and save a little bit of money? That's a big factor if you have jobs that can then be hybrid or work remotely. What I am seeing a lot in the bigger companies, in the cities, people that have larger workforces is they're saying people have to return 2 days a week or 3 days a week, or everybody has to be in every other Wednesday, which I think is kind of stupid because if everybody's in, then do you have enough desks if you have people co-sharing desks? So those kinds of things, but just reevaluating how people are working, which people are productive and can work at home, and which people do you absolutely need back in the office or should be back in the office. The trade-off of that, obviously, is the collaboration is missing. I mean, I know even from my own firm that a A lot of my people work remote, a lot of them are hybrid, but I do miss that kind of, let's sit in the office and talk about the issues of this case together, and that collaboration. And I think people are zoomed out. So really evaluating what your needs are, but with that comes kind of some legal implications. And we'll talk about those on the next slide, but just to go over a couple of the other factors that you need to determine as a business owner, determining what your company's position is on vaccines moving forward. Look, this COVID virus is not going away. We don't typically mandate our people get flu vaccines, but we suggest it. We do things to encourage it. What are you doing with COVID moving forward? Are you going to mandate it moving forward as your office continues, to move beyond the pandemic era? What about boosters? Are you going to mandate them? Having a policy in place and really taking a stance and making a determination is really key. And then keeping an eye on the quarantine requirements and communicating them. The CDC about a month ago put out a great on their website. They have a great little calculator that you can put in, date symptoms started, tested positive, yes or no, exposed, date exposed, or there's a couple factors, and you plug those dates in and it will tell you how long you need to quarantine. It's very cool. So if you look up quarantine calculator CDC, you should be able to find it. And right along with that, as you complete bullet 1, you really need to look at bullet 4. And I can't tell you how many leases I have renegotiated, given space back, negotiated in subtenants, or as you're entering into leases, thinking about those things, because I got to tell you, I am seeing in new lease agreements these quarantine pandemic rules that say if there's a government shutdown, you're not relieved of your obligation to pay rent. So the landlords are taking those actions in the new leases, and as a tenant, you need to be mindful of those and kind of look into calculating that as part of your evaluation of the process. Okay, so this is a new word that I've heard, and I'm gonna ask for a little participation. And Sandy, I see you on this call, and you already know this, so you can't answer. But does anybody know what bleisure means? If you do, put your guesses in the Q&A. Curious to see if anybody's heard of this word, bleisure, and what you think it means. And I'm going to wait for some questions, for some comments in the Q&A. So get your participation. I'm going to keep you guys active. But while I'm waiting for that, I'm going to go to the next slide and talk about virtual considerations. So if you're doing virtual, or you're looking at keeping people virtual, the first thing to look at is whether if you're keeping a job virtual, or you have a job that's opening and now you want to make it virtual, look at whether that person's going to be in state or out of state. One of the biggest, most dramatic changes that I've seen resulting from the pandemic is that there's so much more of a diverse talent pool when you're hiring somebody virtual, because you can hire somebody around the country. And you might not necessarily have to pay them as much as you do if they worked here in the Northeast, or they worked here in person in the Northeast. So somebody in Alabama isn't commanding the same salary as somebody here in the Northeast, but you also have to look at the considerations of equal pay and the equal pay laws. But looking at hiring somebody that's going to be completely virtual, and whether you're going to have that person as an in-state or out of state. And the biggest consideration with that is that where are they doing business and where are you doing business? And this is something that I'm starting to see crop up. I don't see anything in Q&A yet, so I'm just watching. I want to see if any of you know what bleisure means. But let's go back. Doing business. If you have people now that are working for you in another state, you need to evaluate whether you have created a nexus with that state. And by that, I mean, and a lot of people are running into this, is if you now have somebody in Arkansas and somebody in Georgia that you are paying, while the pandemic was happening, a lot of states put in moratoriums regarding registering to do business in that state and tax impacts in the different states. But now that we're coming out of COVID and we're kind of in this more post-COVID, post-pandemic world, states are starting to put into place these requirements that a business owner must register in that state if they are doing business in that state. So if you have 1 or 2 or 3 workers in Arkansas, you need to look at the Arkansas rules and see if whatever the job function is that they are doing is considered doing business. Where are you paying unemployment? Probably in Arkansas. Where are you paying state tax? Probably in Arkansas. Some states have a reciprocal agreement with Pennsylvania in that they can accept the taxes in Pennsylvania for Arkansas. Some states don't. Every state is different. But if you are doing business, which means there is some connection with that other state, you may be subject to taxation in that state, and you may also have to get a registered agent in that state because that state wants a cut of the pie. So that is a huge consideration, and I'm seeing it more and more as people, like, for example, I have a client who is a staffing company, and she typically staffed in the Pennsylvania, New Jersey area, sometimes New York and Delaware, but now she's staffing for bigger companies, and she's staffing in Colorado and Michigan. And so because she's hiring people and she's interviewing people in those states and she's placing people in those states for temporary work, and she is the employer, so she's actually paying them in those states, she is creating a nexus with that state, and she's got to register to do business in that state. So it's a really big consideration, and it is something that could cause legal exposure. So I just ask that you all take a look at that as you consider kind of virtual options of doing business in another state. So let's go back to leisure. So this is a new kind of word that's hitting the market, and it means the blending of business and leisure, and it's kind of cropping out of COVID and the COVID times because people just don't work like they used to. And they're working a little, and then they're doing something that they like, or doing an activity, and then they're working a little, or they work on vacation, which, don't get me wrong, as business owners, I know you all work on vacation all the time. But keeping the lines or blurring the lines as it now seems to be more and more can become an issue if your workers are hourly. And so it's a caution to business owners who have hourly workers to make sure that you're capturing that time. And if they're hourly and they're on vacation, they should be on vacation. And I don't want you as business owners to get into a position where you have people that are hourly workers that are working on vacation because they think they're being diligent and they're not putting in for that time. And then you get into trouble with a Department of Labor type of issue because they haven't been paid for time that they actually were on the clock. So this is kind of a new term that I'm seeing come out. And so I just wanted to kind of throw it your way so you can slip it into a sentence and look like you're so on top of what's going on in HR. So let's go on to kind of the next topic, which is really the Great Resignation. I have seen more resignations and people leaving. Like I said, sometimes it's just my company wants me back in the office and I don't want to commute. I don't want to do that hour and a half to the city anymore. I can do my job at home. I've been doing it at home for 2 years. And I just don't want to go back into the city. Sometimes it's, I don't like the way that things are working right now. I don't like the new owners. Or I'm getting a better offer somewhere else because there's such a tight job pool that people are getting phenomenal offers and they're getting thrown a lot of money their way to come on because people are so desperate for work or for good workers. And so a couple things to kind of really think about in doing that is as you're bringing people on or people are leaving, whether you have or need a non-compete, and we'll talk more about non-competes on the next slide. What policies do you have in place for onboarding and offboarding of people? Do you have synonymous with the non-compete a non-solicit? Do you need a non-solicit? And like I said, we'll talk about that a little bit on the next slide as well. And severance. So if you're letting people go, do you want to pay them severance? And here's kind of like the guidepost for that. Nobody wants to pay an employee, particularly if it's somebody that they want to get rid of. And believe me, I've spoken to many of you throughout the pandemic about this being the perfect opportunity to let that person go. You know, you're shutting down, you're letting everybody go. You can let that employee that you've been wanting to get rid of for a year or 2 years or 5 years go because you're not operating. And then, you know, you're coming back slow, so you're not bringing everybody back, so that employee doesn't come back. But now you are kind of reshuffling the way you're doing things. You're not as busy, or you need to reformat who does what responsibilities, or you just want to get rid of somebody that's not performing. The consideration of offering them severance is huge. And the reason that it's so significant is because the exposure on employers for so many things right now is so great. And we'll talk a little bit later about the Department of Labor and what they're doing. But I just feel like there's so many landmines out there right now for employers that sometimes it's worth its weight in gold to, you know, give that employee, even if they did something horrific, give them a couple of weeks and say, look, this isn't working out. I'm going to give you a severance. Want to make sure that you have a soft landing. Get them to sign those waivers that say they're not going to sue you and they haven't filed anything yet, and then let them go. It's worth its weight in gold. And it allows you to sleep at night for the next 2 years, other than wondering whether or not this person has or will file a claim against you, because the statute of limitations for many of these claims are 2 years. And believe me, when I tell you, I have one on my desk right now that she waited until month 22 and filed. So think about you as the business owner kind of moving along, running your business. You let this person go, and then you've been operating for 22 months, almost 2 years, and now you get hit with a lawsuit for somebody that left almost 2 years ago. So that's why I always talk to my business owners about, you know, if you're letting someone go, sometimes it's worth its weight in gold to consider giving them just a little bit and, you know, parting in better ways. So let's talk about non-competes and non-solicits, though. In all my years, I have never seen non-competes, excuse me, litigated, argued, discussed as much as I have in the past 6 months. I probably have 3 or 4 cases on my desk right now dealing with these issues. Non-competes, non-solicitation agreements used to be something that employees would sign. They wouldn't think twice about signing them. Employers really didn't discuss them. It was just kind of part of the process. And everybody went on their merry way. And employees, for the most part, if they remembered that they even signed it, you know, they left, they went somewhere, they either they weren't competing, or they were, but the employer really didn't care and everybody just kept going. But, a lot of employees that sign a non-compete feel that they, they have this obligation to comply because they signed an agreement that says they're going to comply. And so, so I see the question coming in, and I will answer that question. But what we're seeing now is that the employer where that employee is leaving is enforcing the non-compete with respect to not allowing that employee to compete. The problem becomes is that many of the non-competes and all of the ones that I've been dealing with are so overbroad that typically a court will not enforce them. But the problem is by the time you get to a court, and I have one pending right now in Texas, actually two, by the time you get to a court where that information is pending and where that litigation is, the time for that non-compete has run. And so it's very costly. So I think that there's a benefit to them if they're reasonable. If you have a non-compete that's so broad, like the one that I settled in earlier this year, the guy couldn't compete in selling a very generic product. Like, let's say it was like paper products, like something that's so broad that, like, what does that mean? Does that mean copy paper? Does that mean tissue paper? Does that mean toilet paper? Like anywhere in the country, online. Okay, that's every business that sells anything. That's everything from CVS to Target to Amazon to, so it pretty much said that he couldn't work for 2 years. I mean, it was broad in scope, it was broad in product, it was broad in years. Like it was, and no judge would have ever enforced that. But the problem was nobody wanted to go to court to litigate it. And it became this very contentious battle between the new employer and the employee, who didn't even know he signed it, by the way, because it was stuffed in with all the first day papers and never discussed, and the old employer. And so that while they did prevent him from working and we narrowed it a bit, there is a way to do it, and you have to look at when, like, who is it that you are trying to prevent from doing what? What are you trying to protect? The non-compete will protect a business owner from having someone go out and open a shop down the street or sell whatever your product is for a competitor. That's a non-compete. A non-solicit, but it can't be so wide that you can't prevent them from earning a living. The non-solicit says, I'm not going to go after your clients. I'm not going to open that shop down the street and go after your clients. Now there's like, I'll give you an example of like a CPA. Like a CPA typically doesn't get a non-compete. They might say something that says you can't work within a 5-mile radius of the office or something like that. That's pretty reasonable, but they're more concerned with the non-solicit. You can't go after our clients. You can't go call on them and tell them to come to you for a period of a year. And that protected period is a time period that allows that company where the employee has left from protecting that interest and building that relationship absent the employee that left. So those are their interests are very different. You might need one and not the other, but really thinking through the process of if you need them, why you need them, what are you trying to protect? And if you have them, are you going to enforce them? Really talking about your employees who you are giving a non-compete to when they start their employment. And when they leave, handing them that non-compete and just saying, hey, I know you're leaving. Here's your non-compete. Just a reminder, you can't do this in this territory for this time. And just kind of doing it that way. And I would say most people, if you're up and on the above board about it, most people will honor the agreement that they entered into. It's only when that agreement becomes so broad that it blows up. And when should I enforce it? Well, that really is a question of, first of all, do you have an agreement that is enforceable, or do you risk by going to court getting not only that agreement invalidated, but a judge saying this agreement is invalid and you have 100 others that are just like it that are now all invalid because the judge found that the template that you're using is invalid. So, but if you do have a protectable interest, like you have, I had a case a number of years ago. It was a financial advisor, and she went from one firm to another, and she had like $100 million book of business. And she was just a financial advisor, but she had a huge book. And so that bank did go run into court and say, hey, you're stealing all this business from us because you're pulling these clients and you have a non-solicit agreement. So really thinking through the process of, do you need it? When do you need it? When do you enforce it? And if you're hiring someone, particularly in a sales role, asking them whether they have it, because the problem is when you're bringing someone on, if they are competing and they don't disclose, the employee doesn't disclose that they have it, it becomes an exposure to you, the business owner, because an old employer is going to sue you, the employee, and the new business owner, or at least send a nasty gram to both to say, do you know that this person has it? And do you know that are they violating? So I just kind of wanted to go through, because like I said, this is probably one of the hottest topics right now in employment law. And it really doesn't matter if you have a 2-person business or a 200-person business. This is a huge issue. Let me go back to the question. The question is, what kind of claims can an employee we let go do that would warrant us paying severance? It's not a few days. We're talking about what kinds of risks are we talking about here, and how often does the employee win more than the amount we'd pay them in severance? So that's a great question. The biggest claim is a Department of Labor claim, which is I wasn't paid. It could run a variety of ways. I wasn't paid all the overtime I was entitled to. I wasn't paid for the breaks that were under 15 minutes. I had to work through my lunch a lot, and I wasn't paid for that. It could be one employee that brings that claim in court, or it could be a Department of Labor audit, in which case they audit all of your workforce. Those are claims. It could be a discrimination claim. It could be, and again, this is perceived. Perception is reality. So this could be an employee who perceives that you let them go on the basis of their disability. And so what this looks like is, so I just yesterday got a decision back from the EEOC where the employee was let go. We actually, like I said, I represent a staffing company. The staffing company placed the employee temporarily in a workplace that absolutely needed somebody right away. She was working there like a month, never disclosed, and the staffing company actually never met her because she was on Zoom. So she looked much like I look right now. You see from here up, never disclosed that she was pregnant. The staffing company never knew. She called out of work and said she was having stomach cramps, and lo and behold, she delivered a premature baby. Wow, I know that's so many more discussions we could have on that, but we'll put those aside. And we'll say that she filed with the EEOC because the place where she was placed said, we're sending her back. We need somebody else right away. We need another body. And so the engagement that she had at the company where she was placed ended. She was still on the rolls of the staffing company for when she came back. We would try to find her another placement, but we didn't have one right away. And she filed a claim with the EEOC saying that the staffing company discriminated against her on the basis of pregnancy. We never let her go. She was still on our roll. So that's a little bit different because we never let her go. But in that case, it cost the employer my time, probably more than a $2,000 or $3,000 or $4,000 severance of my time just to answer the EEOC complaint, prepare like a position paper, review all the documents, meet with the witnesses at the company. So that's one case. And then I had another case that the employee was let go through COVID, laid off, probably not going to come back, but who knows? I mean, the company didn't know at the time. They laid everybody off. The factory closed, and the employee sued in federal court saying he was not a supervisor, he was misclassified, and he was entitled to overtime for all the hours he worked in the past 2 years, because that's how far the look back period is. So the company spent probably 50 grand in litigation costs in defending the lawsuit, which ultimately ended up with a settlement just because a trial would have been so much more than what they ended up settling for. So it's not necessarily, I mean, the cost of what the employee could get, it's the legal fees to defend the lawsuit or the EEOC claim, or if it's the Department of Labor, sometimes they go on for 2 years because they look at all of your employees. They go back for 2 years. They look at your payroll. They send you a nice big fat list of all the documents they want. So it's the business interruption. They interview your employees. So it's not always what you would pay them. And for severance, I got to tell you, I just did a severance for a small nonprofit, like 10 people. They had a woman who accessed some files that she was not permitted to access. She had been with them probably 4 years, something like that. And they were like, nope, this is not acceptable behavior. And they wanted to let her go. And they paid her like 2 weeks worth of severance. It was probably $2,000-$3,000. Like, it wasn't a lot of money. We drafted the severance agreement. We said, they said this, we really have to part ways, and we want to give you a soft landing, and we'll pay you your vacation time, and we'll pay you the severance. It was probably all told maybe $3,500, and she signed it, and she waived all of her rights to sue and all of her claims. So it's really a cost benefit analysis, and it's not necessarily what the employee could get at the end of the day. It's the business interruption over the next 2 years, whether they file a lawsuit or they go with an agency. And it could be sooner. Like, this pregnancy one was probably 6 months, but then it's also the legal fees to defend that. And you could have EPLI insurance, but you don't necessarily have it. So a lot of companies don't, but I highly recommend it because it's not that expensive. I'm confused. Let me go to the next question. My understanding of severances was that it was just a thing for executives or managers, and the numbers paid out was in the tens of thousands or hundreds of thousands for those positions, not 2 or 3 or 4,000. More like, no. A severance agreement you can give a severance agreement to anyone. Any employee that you are separating from. Sometimes it's called a separation agreement. Sometimes it's called a severance agreement. It really doesn't matter. Typically, if they've threatened litigation, it's more of a severance agreement. If you're just letting them go, it could be a separation agreement. But it's not only for executives. You can use it for anyone. And I mean, I've used it. So, for example, I have a client that's another factory. They sell a food product. They let one of their employees go. The employee was just habitually late, and the employer was kind of like, I'm done. He's a poor example to the rest of the workforce, and he's mouthed off to me, and I find that disrespectful, and so I'm going to separate with him and say it's just not working out, and I'm going to give him a week of severance at his hourly rate, which could be $20 an hour. And I'm going to pay out his vacation, which I don't necessarily have to do because it's not accrued, and call it a day. It does not. There has to be an exchange of value for the waiver of the claims, but it doesn't have to be in the tens of thousands of dollars. Now, don't get me wrong. Like, I had a executive that left, that was terminated from a position unlawfully, like truly unlawfully. And we sent a demand letter and said we had threatened litigation if he was not given more. And I think they gave him like 2 weeks. And he was like, no. I've been here 8 years and or 9 years or something like that. And he was a high performer. And we were able to get him 9 months of severance. So yeah, I mean, it does happen that way. And if you have bigger executives, usually if they either threaten litigation or two, they've done something that is egregious, but the company's like, you know what, this person, like, we don't want them to sue us. It's worth it to us to pay X dollars to avoid that lawsuit. So that's why I'm saying it is very critical when you start looking at who your people are, or you're letting people go, or you have somebody that's a little bit of a loose cannon, to really, call me, talk to another attorney talk to your HR executive or resource if you have one, to consider offering severance if you think that there's a business exposure there. It does not have to be only for executives. How is the length of time determined? It's usually, it depends. If you're letting somebody low level go and they haven't been there that long, 1, 2, 3 weeks. A good gauge for a long standing employee is 1 to 2 weeks for every year. The most generous I've seen typically is 3 weeks for every year. You see that in the pharmaceutical world, and they have stated and standard termination policies and severance policies in their handbook. But usually, 1 week for every year. So if somebody's there a year and a half, you give them a week. Always think that maybe they might come back. They might say, well, I want a little bit more. Then you give them 2 weeks. But usually, especially for these people that haven't been there that long, and there's you feel like there's, you don't know them that well, and maybe there's a risk there. So definitely worth considering. So let's kind of move on to the flip side of the coin. So now you're losing people. How do you attract talent? We kind of already talked about the pros and cons of non-competes, but really looking at why people are leaving and looking at what can you do to attract those people. And looking, some of the things that you can look at when you're looking at attracting people are, evaluate what you're paying these people. Is it still market norms? Does it still fall within what's acceptable? I know everything's more expensive now. That includes salaries. And so are the salaries that you are paying these individuals where they should be? And I could tell you that if you're still using the salary ranges that you developed in 2015, you need to look at them again. Some really easy things that you can kind of offer and throw at people. Benefits, not really easy, not really cheap. But looking at non-financial benefits, contributions toward education. AFLAC costs an employer nothing. Great benefit for employees. They have different policies for different things. They're super cheap, but it costs the employer nothing. Contributions toward education. You know how many people take an employer up on that? I would say under 10%, but it's a great Benny to put on your list of, we offer this. Referral fees for for people that are employees that refer you to a new employee that you will eventually bring on, that's a great way to get good talent. And a seat at the table, get them involved, get them on a committee, get them as part of some kind of process or process improvement, and giving them some kind of charge to get them involved. These are things that people are looking for. If you're looking at millennials, they're also looking for, what is your purpose? What is your charitable purpose? Why do you exist? Why do you do what you do other than to make money? So that's kind of the millennial perspective. And for those of you that have seen me before, that know a little bit about me, or that have had that I've had the pleasure of working with, one of the things that I was telling Linda and Ed and Charlie about is premiering, my firm has now opened and started a consulting company called Lutel Consulting. You could check us out at lutel.com. So we have the law firm. We also, the law offices of Christina Reger is not going anywhere. But what Lutel does is we do a lot of diversity, equity, and inclusion training, strategic plans, coaching for businesses of all sizes. And so part of what we do in this space is we work with companies on attracting and retaining talent. Why are you losing talent? Aside from the legal issues, like we layer kind of the legal lens over the DE&I lens on everything that we do. So whether we're approaching something from a legal issue, like why is somebody leaving? They're threatening to sue us, or we have a complaint of discrimination, or hey, we're losing or we're bleeding people. How do we keep our people? Let's look at this from the perspective of the culture lens. That's kind of what we do. And so looking in the fields of, are your people happy? Do they feel safe at work? Are they coming to work? Do they want to come to work? What we do at Lutel is we do ask, act, measure. So we ask the questions, we do assessments, we get the data. We are very data driven. Then we look at the data, we evaluate it, we crunch the numbers, and we act on that. We work with you, the business owner, to say, where can we impact change? How do we take these numbers and look at them and then make changes to make your company better, to make your people happier, to make them want to stay, to attract new talent? And then we remeasure to see, was that effective? What was the plan that we put in place, that strategic plan, was that effective? And that's really important. So you're looking at the whole life cycle of an employee, and this is really significant post-COVID, because I feel like COVID and the pandemic kind of took everybody's business sandbox and flipped it over. And then for the past 2 years, businesses are kind of scrambling to take all their sand and put it back in their sandbox. But now most of the sand is back in there, but now you have people leaving, people coming, how are you getting people? Why are your people leaving? And so this is really a significant part of this kind of post-pandemic recovery period to reevaluate as a business, because there's not one business on the planet that is operating exactly the way that they did for the past 10 years pre-COVID or the past year pre-COVID. Everyone's business changed to some degree, and how they operate changed. And it's important as a business owner to recognize that and to kind of evaluate that and make sure you're capturing that, and really looking at, particularly as you're looking at trying to get those people back in the office, if that's part of your goal, creating a culture where people want to stay. And it's interesting because we do these assessments, and what we find is people don't feel safe at work, whether they don't feel heard or they don't feel trusted. There's a significant issue, and the numbers always come back low on whether people feel safe at work. And that might be physically safe, that might be emotionally safe, that might be I'm African American and I'm afraid to express my views because they're not appreciated. I'm a certain religion and I'm afraid to vocalize my needs because I might get disciplined. It could be any kind of safety or trust issue. So really strengthening the organization's trust and communication, being intentional about engaging all of your employees, not just this core group that always is vocal or always wants to be volunteering, but making everyone feel like they belong, particularly if you're bringing people back and people haven't been together. And look, I know people that haven't left their house in 2 years, very rarely. It's shocking, but it's true. And let's face facts. You can literally live in your house right now. You can get your groceries delivered. You can get your toiletries delivered. You can get your entertainment on your computer or your TV. You don't need to leave your house, but people leave and it's like, whoa, other people. And I've watched it at different events that I go to where people just, they don't even know like how to interact because they're just not used to seeing groups of people. So giving employees a voice and listening to what they have to say, investing in talent. So this goes back to kind of those benefits, like what are you doing to invest in your talent? What are you offering them? Are you offering them on-site training? Can they go to a SCORE presentation if there's one that interests them? Like, what are you doing to make them feel like they are growing? Be transparent and equitable around career mapping and promotions, and have an open conversation about difficult topics like inclusion, equity, and psychological safety. And this is kind of where we come in a lot, because employers see this and it's like deer in the headlights. They don't know what to do. They don't know where to start. Or I can't tell you how many calls we get where we hear, I know I have to do something about this DE&I thing, but I just don't even know where to start. How do I do this? And really, DE&I is not okay, let me check the box. I did one training this year. And that's not what my company Lutel is about. We are about coming alongside that employer and working with them and helping them change their culture and helping them provide a more inclusive culture to their workforce. And you will have people that want to stay and you will have people that want to work there, but this is what people are looking for. And if you want people to stay and you don't want them walking out the door with the Great Resignation, and you want people that are going to quality people that are responding to your ads, this is the things that they're looking for. So any questions on that? Because we're going to move off to another topic. No? Okay. Did I get all the questions? Hold on. Let me make sure I got them all. Oh, no. Are nonprofits more enforceable? Can we receive judges' favor more often than not relative to non-competes, or is it vice versa? I haven't seen a distinction on that, Michael, with respect to non-competes. I have not seen where a judge will say, oh, well, this is a nonprofit, so let's let them bend the rules. But I do see more and more nonprofits that are really engaging in non-competes more so than they have in the past. But I don't see a difference in distinction in terms of the application of the non-competes in the legal system. Okay, so arbitration clauses, if you have contract employees, whether they're employees or even independent contractors, really look at whether you have arbitration clauses and what those arbitration clauses cover. New law came into effect, it got cut off a little bit, 3/3/2022, that prohibits arbitration clauses for sexual harassment claims. So what that means, and the law, because Congress is never short on its names, Ending Forced Arbitration for Sexual Assault and Sexual Harassment Act of 2021, passed 3/3/2022. But what this act essentially did is there's many employers, whether it's through contract or through policy or through handbook, that or through employment agreement, that had these agreements that said, if you have a sexual harassment claim, you must bring it in arbitration. And what that created and did in the workforce was it created a system where a bad actor could harass someone. That person could bring a claim. If it got brought in court, the employer moved it to arbitration, and that's where it was resolved. And so if it got resolved there, no one else knew about it because arbitration is confidential. And so there was no media, there was no public scrutiny, and there was no, for lack of a better word, warning to the general public that, hey, there's a predator that works here. Think Harvey Weinstein. He had arbitration clauses in all of his employment agreements. And so anytime there was a claim, it was sent to arbitration. So no one else knew. No one else knew that he had settled these cases because it was all done confidentially. And so he continued to be able to operate under the mode that he operated and continued to do what he was doing, and no one could find out. So that was the purpose of this law. Typically doesn't impact small businesses unless you have agreements that, and this is kind of where I see it a little bit more, that you got from the company that you bought your business from, or you got from your neighbor's company and you're using their sample employment agreement, and they had a bigger company or a different type of company, and that this language was in there. So, all I say to my smaller businesses and my SCORE businesses, to the extent that you're a smaller business, is check out if you do have employment agreements for some of your employees. Make sure that you take a look at them and see if they're in there, and caution that they're no longer effective and enforceable. Okay. So let's talk about what's going on with the Department of Labor. One of the things that I typically like to stress with the Department of Labor, which I've seen kind of over the past 10 years, is that the Department of Labor is obviously an agency of the federal government that is largely funded by the president's budget. And so I say this not to get into a political debate with anyone, but to say that Republicans are typically, the Republican Party is typically pro-business, and the Democratic Party is typically pro-employee. So depending on who is in the White House will dictate how effective and how active these agencies are. And so, for example, when President Obama was in the White House, the Department of Labor grew very large. So did the National Labor Relations Board and other agencies that are there to protect employee rights. When President Trump came into office, those agencies' budgets were significantly slashed. A lot of the regulations that were put into place under the Obama years were repealed under the Trump years. And now you have President Biden, who's Democratic, who's, so again, pro-employee. And so what we are seeing is more activity in the Department of Labor. That's bad news for businesses because these agencies are in place. They are employee protection agencies. And so I always caution my businesses that when you're dealing with, in a time where you have a Democratic president in the White House, these agencies are typically more well-funded and more active. And we've started to see that in connection with some of the issues that are coming out. There's definitely a lot more policy making that's happening, and there has been with COVID for sure, but on non-COVID related issues. So one of the big things that we see is the Department of Labor's, again, which, keep in mind, 4 years ago, this was the issue, really focusing on evaluating independent contractors. So this was 4 years ago, well, probably now 5 years ago, and beyond. This was a big issue. Whether you had employees or workers that were independent contractors that should have been employees was a big issue. And so this is now becoming center stage. Now, keep in mind, under the Trump era, the gig economy flourished, and there was so much promotion of this gig economy independent contractor worker that, came in and worked for your company for a little bit and then left, and that was supported and endorsed. That is not a view that's supported by the Department of Labor, but you had a Republican pro-business and president in the White House, so he's supporting things that generate business and business endeavors. And now you have a Democratic president who's supporting the rights of workers and saying, hey, independent contractors are cheaper for a business. They don't cost a business insurance. They don't cost a business workers' comp. They don't require business to pay employment tax. And so those are all savings for a business that don't protect the employee. And so they're focusing now again on the businesses that use independent contractors and whether those independent contractors are truly independent. And it's a revenue generator, right? It's a revenue generator for the state. It's a revenue generator for the city because there's taxes. If they determine that you have 10 independent contractors that truly are employees, those are lost revenue taxes that the Department of Labor is saying, hey, you owe this to us because these people should have been employees. And so that's a significant parting back from where we were 2 years ago. Now, the other reason this is so significant right now is looking back at this post-pandemic world. What I am seeing as an employment lawyer is as businesses are struggling to come back, reevaluate their workforce, they need somebody, but they don't need somebody full time, is they're hiring independent contractors to fill the gaps where they need workers and it's cheaper. So they'll bring on an independent contractor and hire them for 20 hours a week to do whatever. Like I see marketing companies that have marketing people that they're using as independent contractors. Now that's a whole nother world from the way that my marketing people tell it to me, but I see, let's see, businesses that are hiring, instead of hiring like a part-time worker, employee worker, they're hiring these people as independent contractors because it's quick on, quick off, easy onboarding, easy offboarding. I don't have to pay them taxes. I don't have to set them up with my payroll company. It's so easy. Just pay them a flat rate per hour and done. And the Department of Labor is saying, well, but they're not. If you go through the Fair Labor Standards Act test or even the IRS 20-factor test, they're not really independent. They're just working for you part-time. So that's why this is so significant right now in the kind of post-pandemic coming out of and starting to work again. And so I caution businesses, particularly small businesses, that really evaluate your labor force and look at whether these people are truly independent of you, such that they fit the tests for an independent contractor, or are they somebody that should be an employee or a part-time employee? Because this is where the Department of Labor, we're starting to see focus again. Okay, so let's go. So, and the way that we see that focus is whether it's by a complaint, which is how it typically is, or there's a focus on an industry, which sometimes happens. The way that these get uncovered is a wage and hour audit. And so these are some of the things that the Department of Labor will focus on. They will look at, what are the salary thresholds to pay someone a salary versus the hourly thresholds, and is that employee meeting those, or should they be paid overtime? What are their job functions? Are they doing a job that entitles them to truly be paid overtime? or are they truly a manager? So the one case that I was telling you about, that factory worker that was let go, what he was arguing was, yeah, I have the supervisor title, but I don't fit the criteria for what's required of a supervisor. And so I shouldn't be his allegation was the company just paid me as a salaried employee and called me a supervisor, so they didn't have to pay me overtime. But I truly wasn't doing all of the things that fit the qualification for a supervisor. So I should have been paid hourly and I should have been entitled to overtime. And what happens, to go back to that question on that about the severance, is when you're going back to somebody, and keep in mind, two concerns is if you have somebody that's salaried that may claim that they're hourly and they're not doing a position that's truly salaried. The concern is if they're salaried, the employer is not keeping track of how much time they're working because they're salaried, right? The employee is. And it becomes, and even if they're not, and they say, well, I worked an average of 5 hours a week, it becomes the employer's burden to disprove that. So it's a very tough burden if the employer did not keep records of how long that employee worked because they were operating under the assumption that they are salaried. So in terms of a wage and hour audit, it's sometimes good as the employer to do that on your own and really kind of look at some of your people, particularly those that are kind of on the threshold, and see if they truly fit the definition of what is hourly versus salaried and where they fall. The other big thing is if you have people that are virtual, looking at the clock in, clock out procedures. How are you capturing their time if they are hourly? Becomes much more challenging if they're not sitting in an office with you or sitting in or coming into work in a factory where they punch a clock, but they're working at home. And I know that I feel like, at least from what I've seen, the legislators, the governments, that everybody was a little more lax during COVID as they let businesses kind of find their way and they wanted to keep people working. But as you're kind of coming out of this, if you have rules that are continuing to work at home and they're hourly, how are you capturing that time? If they're working more than 8 hours, how are you prohibiting that to avoid the payment of overtime if that's your goal? And whatever you're doing, document. So I just worked with a client yesterday. She's a therapist. She has therapists that work for her as independent contractors. And so we went through that FLSA test and looked at all 6 factors and came to like what facts support or don't support that factor. Like, is the person integral to your business? Yes. Well, that's a factor that's weighing on the side of the employee. Do they bring their own equipment and tools to the job? Well, they are in charge of their own license, their own insurance, their own scheduling. They work out of their house, so there's no office that we give to them. So that to me is more independent. So what we did was we went through those factors and then we documented. We looked at what the law said and then we applied the factors to her people and we wrote it all out and documented it, put it in a file. So if the Department of Labor ever comes back to her, she can say, hey, I did this analysis. I did my due diligence. I worked with legal counsel. And the whole point of that is to avoid any kind of penalties or fines. Sometimes the problem with the Department of Labor is, they're going to look at the sky outside. I'm looking out my window and they're going to go, it's purple. And you're going to go, what are you talking about? It's white or blue. And they're going to go, nope, it's purple, because we say it's purple. And so it's purple. And that's always a challenge. But there's a lot more than just the wages that go into these audits. There's penalties, there's fines, there's interest. And so kind of mitigating those damages by kind of doing your due diligence and documenting is significant. So So there's a question about related to the subjects you're covering today on HR, what considerations should a solo be making if and when considering to hire a virtual assistant? Because we are asking them to do certain things. Must we classify them? So I'm going to say this is a pretty unique set of circumstances, and I can tell you that, yeah, if you're hiring somebody in another country, that's a whole nother ball of wax. But what I've seen, and I haven't kind of researched this issue, is they're not subject to the United States laws, which is why they're attractive. I believe I'm going to qualify that with I have not researched the issue for a client, so I don't know that for fact, but that's what I'm hearing in the pipeline. But some of the things, if you're a solo and you're looking to hire a virtual assistant, and you're looking to hire them probably as a 1099, do they work for other people? Are they working for you 40 hours a week? If they are, then they're not independent of you. If they're only working for you part-time and this is the business that they provide, probably are independent of you. And then, do they have their own insurance? How are you keeping time? How are you paying them? Workers' comp is huge, and it's something that, and let me go just flip to the next slide, because this is kind of actually, let me flip to this slide. So, these are some of the policies that I recommend employers look at. And one of them, is it's actually not on here, but health and safety policies, I guess I would put it there, is workers' comp. To me, this is a huge disaster waiting to happen. And the reason I say that is because if you have an employee that's working at home, and that employee was traditionally in the office and now they're working at home, are they covered under your workers' comp policy? Because you have them slated probably when you got the policy as an office worker. Okay, so if they're working at home and they go to the kitchen to grab a sandwich and they come back to their desk, or they're leaving their desk to go to the kitchen to grab a sandwich, are they on lunch break? And even if they are on lunch break, they trip over the cord from their desk and they break their leg. Is that workers' comp? I'm going to give you one better. They are taking a Zoom call, because I've seen it all, and they're driving and they get into an accident. Is that workers' comp? Or they're just on their phone and they're driving little Johnny to soccer practice and they get into an accident. Is it workers' comp? I don't know. I'm not suggesting that I know the answer to these. I'm suggesting that you ask. So these are some of the issues that, as you change post-pandemic, kind of come out of this world into how you're operating moving forward. These are things that you need to look at. Like, and I think we kind of already talked about COVID and vaccine policies and looking at them, and what is the company's position moving forward. Health and safety policies, whether they're coming back to the office, cleaning, masking, whatever the situation is, keeping your people safe, which is an OSHA requirement. Reimbursement policies. This is a big one. And this is a big one in terms of going back to the benefits. And the reason why it's a big one is because if this employee is now working at home and they used to work in your office or in a location, and I use an office because it's a little easier to make the example. So they worked in your office, they took up X amount of square footage, 500 square feet for their office or their desk. And you gave them a computer and they use the Wi-Fi and they use the printer and the paper and the ink and a phone on the desk and 2 monitors. And all of these things, and the heating and the air conditioning in the office, that all goes into the employer's costs. Now they're home. And you've successfully been able to give back some of the office, or you have a co-sharing space, or you have a smaller space. So as an employer, you're saving money, and you have an employee that is now working at home, and they're paying for their own Wi-Fi, and they're paying for their own phone, and they're paying for their own printer cartridges and their own ink. And you give them a laptop, that's fantastic. They might not have a chair that's ergonomic, or a desk setup that's as good as what was in the office. They might start to have back problems down the road because they're not in a good chair. All of these things start to snowball, and they build resentment. And then they get the call from the company down the street that says, hey, listen, we have this virtual position for you. We set you up at home. Our occupational specialist comes out. They set up your desk. We give you, we give you a phone stipend. We give you a computer. We give you a printer. We give you. So that looks really attractive, because all of a sudden the employee says, how come my current employer's not doing that? So these are all of minimal cost to you, the employer, particularly if you used to pay for them in the office setup and now you're not. And so they can build resentment, but they're also nice to have perks to an employee that might not cost you that much if you paid for them in the office and you're no longer doing that. So reimbursement policies is a big one to look at if you're starting to change the way that your workforce operates moving forward in terms of who's home and who's not. Vacation policies, again, leisure. If somebody's working part-time and they're on vacation for a week and they end up working 4 hours every day for you, are you tagging them with 5 days off? These are challenging issues. I'm not going to pretend that these are easy issues. They're not. They're challenging, and they're things that employers are so busy. I know even I am in my office, and I'm, that you don't always think about, but you need to, because these are the reason people are leaving. And reporting time, like, how are you reporting it? How are they capturing it, particularly if they're not in the office and they're hourly workers? And here's another one. And I think this was on the previous slide. Maybe. Oh yeah, don't forget confidentiality. I have a case right now with a payroll company, and the predecessor company, their employees worked at home, and they were allowed to take files home that had employee data and social security numbers and bank records, because the employer thought, well, this person's, working at home and I'm getting my work done. I'm getting work out of them. Well, what are you doing, the employer, now to protect the confidentiality of the data that's been entrusted to you, depending on the industry that you're in? And so, and it's not just the paper files that might be sitting on their desk at home, because that's where they're working now. Like in an office, you can lock the office and that's it. Nobody else sees it. Now they're in their home, their kids are home, they have people coming over, like it's all sitting out on their desk. Do you have any policies for that? Do you have policies to protect the data that's being transmitted, because now they're not in the office, they're not all on the same Wi-Fi? Do you have a VPN? If somebody leaves and they're a virtual position, how are you protecting getting that electronic data back? If it's not your computer, and this is one of the issues that I'm having in one of my cases, if it's not your computer, how do you get it back? It's electronic. It's not like and this is what this company wants. They're like, well, we just want your computer and we'll fish through it all. And I'm like, wait, no, you're not getting my clients' computers that are their personal computers that you didn't pay for, or their personal phones that you didn't pay for. But, and the response from the employer side is, but our stuff is on it. Okay, what did you do to protect your stuff? So these are now kind of issues in the whole new world that we live in that employers kind of never had to think about before. the employee leaving and walking out the door with all your confidential data on their personal laptop because you didn't buy them one, or your cell phone, or their cell phone because you didn't buy them one, or they're not using yours, or you can't shut off access to your files. That's huge. I mean, you cannot protect this risk 100% because they could stick a stick in their computer and download it all, but there's ways to detect that. And it's just about thinking about these issues now and trying to put as much in place to prevent them. So looking at the new ways you're operating and thinking through these types of issues. But also, it's really important that you define expectations for your employees. Like, what are you doing? How are you telling them, this is what I expect from you? I expect you to be on at 9 o'clock. If there's a Zoom call, I expect you to be dressed nicely, professionally, like you would in the office. Address teleworking policies. I think we kind of talked about this. Like, what is the expectation? That they're going to be working 9 to 5, that they take a lunch break, that they don't go get their son Johnny from soccer practice. And here's a big one that I run into a lot. They are a new mom and they have a kid at home and they're working while their kid is at home because their kid is not in daycare. And so are they getting their work done? And that's great if they are. But then I have other companies that they're not permitted to do that. I can't remember. I just had that the other day, where the company is not, it was a home care worker, and the company's policy, because it was the government's policy, was the caregiver couldn't have a child at home while caring for the person that was there. So again, how are you looking at these things? Are you dressing them? Consider at-home outlays. Don't forget confidentiality, and review insurance policies, which is, again, that workers' comp, that general liability. If an employee that's working at home has a client come over because they want to meet them and they have the space to do it, and the client trips leaving the employee's house, is that covered under your insurance policy? These are all the things that employees need to think about. Which policies are rolled up in the employee handbook? Would finding a well-reviewed HR person through step before coming to a lawyer such as yourself to refine. I don't know those sites, Fiverr, Upwork, and Behance, but I can tell you that I have come across LegalZoom, which is a disaster. We do handbooks in my office. We do handbooks like we do many other things, particularly for small businesses, on a flat fee. And we work with you to customize that handbook. I don't know the quality of those sites, but I can tell you sometimes it costs an employer more to revise a handbook than it does to start from scratch to do one. But I can also say that sometimes employers, I've seen in handbooks, like, for example, I've seen an FLSA policy. Not an FLSA policy, a leave policy, and the company had less than 50 employees, so they didn't have to comply with that rule. So what I do see is sometimes employers put in policies that they don't have to comply with because they don't meet the minimum amount of employees. But the way the courts look at that is, if it's in the policy handbook, the court will hold you to it, even if the law doesn't require it. So let's go back. I think I have one more slide. So again, very good timing. Now is the time to update your handbook. We in my office do a ton of handbooks, and we revise them and we write them. So now's the time to do it. Make sure that it's up to date with how you're operating. Incorporate new policies. I see Ed, I'm on my last slide. Incorporate the new way your company is working. And if you're restructuring or you're letting people go, consider that severance. If you're not linked in with me, link in with me. I try to post every now and then when I see things that are relevant to small businesses. Or you can get my blog. I promise I won't overwhelm you because I don't have time to write too much, but I do like to write when things are relevant. And so if you want that, you can get that on my website. That's it.
Well, thank you, Christina. Fortunately, you also answered all the questions, and we right at our appointed time, so everything is done. But we really thank you for a very comprehensive sort of rundown of, and I'm sure if you did it again tomorrow, there'd be a half a dozen changes.
Yes.
The government has no problem in just constantly screwing up people's lives. I want to thank everyone for hanging in there and listening to this. It would be impossible to take notes. That's why we give you a transcript of this, and that's why you also get a copy of the slides. So you can sit back and read through it slowly and figure out what you need. We're right at our time, and I know people have to hop back to work. I'm just going to turn it over to our chapter chair, Linda, for a closing remark. Linda?
Christina, my goodness, how the world has changed and how there's so much to do. It's kind of scary. There is one question that somebody circled back on that you might want to look at. I think you answered a question about nonprofits, but the question was about non-solicits. Are non-solicits more enforceable? Can we receive judges' favor more often than not relative to non-competes, or is it vice versa? I think you kind of asked for you answered about nonprofits.
See, it's very hard to talk and read and comprehend.
I know. Not your fault. That's why we do it at the end.
Yeah, so I think non-solicits are definitely more enforceable, only because I feel like, that's a much more tangible, you have a vested interest in that client because they're your existing client, or they're a client that you
Move your microphone closer, Christina.
Better?
Yeah.
Okay, so they're a client that you have or you're trying to get. So judges are more compassionate, I think, in my opinion, about that being a very tangible, protectable interest versus a non-compete. In that case, what they'll do is they'll say, is it reasonable, right? Which is, reasonable is not a black and white standard. Reasonable could be different for me and for Linda and for Ed. And so, and it could be different depending on the day of the week, frankly. So I think that, I think non-solicit and not poaching somebody's clients is definitely something. And if that's really more beneficial to your company, I think that that's an easier one to enforce.
Okay. There was one other too. You probably addressed it, but it's a little bit more specific. Which policies are rolled up in an employee manual handbook? I think we talked about that, but the question is, would finding a well-reviewed HR person through Fiverr, Upwork, Behance, and the like to draft one up with everything be an okay first step before coming to a lawyer such as yourself to refine, add, change clauses they may have missed? So something's better than nothing, and then it's a starting point.
Yeah, I mean, I think I read that. I didn't know I thought those sites were places where you can actually get a handbook, and I don't recommend that. But working with a seasoned HR person for sure. And then we review handbooks all the time. And sometimes we come in even early in the process, look, there's a wealth of work out there. So, if you said, hey, we hire this person and they're going to do the handbook, can you oversee it, or can they be a resource for you? We work very collaboratively with companies. We want to get you the best result and the best protection at the lowest cost, because some of the companies that work with SCORE are smaller, and we want to make sure you're protected first and foremost. And so, that's certainly definitely an option.
Yeah, I think that, and something like that is better than nothing, right?
Right.
As a starting point.
Yep.
Okay, I'm just going through the chat to see if there's anything else. I think lots of good comments about you. Yeah. And you're a plethora of information, which we knew going in. We knew that going in. And the law is so confusing for most of us. And HR changes, as Ed said, constantly. So it is a new world. And this has been, a great presentation to kind of draw attention to what's happening today. So I thank you for everything you put into this. I thank everyone who has attended. and look for our seminars that come up every week. What's next, Ed?
Well,
Next
we're
week.
going to have successful strategies for women-owned businesses, for small business.
All
And
right.
then we're going to do basic accounting. And then on the 19th, how to determine success. Start with your why, which is a very interesting presentation. And then how to give a dynamic presentation.
Okay, awesome.
We're
That's
trying
great.
to sort of mix it all up.
Yep, that's awesome. Well, thanks again, everyone. If you need help, please reach out to us, buckscounty.score.org. Christina's information is on the slide here. So I thank you all, and we'll see you next Tuesday. Thank you.
Take care. Thank you.